Hi everyone, we're talking today about what to do if a customer can't pay you. So not just that they don't want to pay you, but they don't have the cash or the assets to pay you. What are your options? Hi, I'm Alex Martin. I'm a commercial litigation specialist and these are my noble legal tips for business owners. Okay, the topic for today is what to do if a customer can't pay you. So if they don't have the assets, they don't have the cash and they can't make payment to you, what are your options? Now, I'll probably give you the lawyer answer, which is the best time to protect your deal is before you do it or when you're doing it. You get the best security at the time you're signing up customers. So if you can get a personal guarantee from customers or you can get property security against the customer, that's from their home or their factory or their equipment or whatever it is. If you can get property security and a personal guarantee, you're going to be in a much better position if the company you're dealing with goes into liquidation and can't pay. But assuming you've done all of that or that hasn't worked and you've got a deal that you've done some time ago and you're trying to enforce it, what do you do if the customer doesn't have any money? So typically the customer will be a company. That's the first thing to check. You want to make sure that you're actually dealing with the entity you think you're dealing with. It might be that you're supplying one entity and your actual credit terms were signed by another entity. So you might want to look at who you're supplying to and who your credit terms were signed with. It may be that you have another option if you signed credit terms with one entity but then supplied the other, you may have a claim against both. If you're dealing with an individual, you may also have a claim against that individual. If they've made a misleading statement to you or they've made some other legal wrong in the course of dealing with you, you might be able to drag them in personally to the litigation. It might even be that they purchased from you personally if they didn't purchase on behalf of the company. So that can be a grey area and certainly worth exploring. The reality is if a company you're dealing with goes into liquidation and doesn't have any assets or has assets that are encumbered by the bank, so has mortgage assets, then you're unlikely to recover anything, and that's a serious risk. So you've really got to think about that when you're signing up new customers. If they go into liquidation, what do I do? How likely are they to go into liquidation? What assets do they have? And not just what assets does the director appear to have, not what kind of car is the director driving, what kind of house do they live in, but what assets are actually owned by the customer that you're dealing with. That's the entity. So it may well be that the director lives in a lovely house, but that might be owned by the director's partner, or drives a car and that car might be under finance. So signs of wealth don't necessarily mean wealth with the entity that you're dealing with. So if you're signing up a customer, make sure you get as much security as you can, find out about them, and if it's a $2 company, a company with no assets, then you might want a personal guarantee from the director or property security. That puts you in the best position you can to recover from your customers. Thanks for listening and we'll see you next time.